Well, good morning. We're going to convene this public meeting. It's not a hearing. It's a meeting under the development agreement involving Talus subdivisions, and the purpose of the meeting today is to look at a remand from a Superior Court judge of King County that has asked the city to take an additional look at the subdivision of Talus Parcels 7 and 8. The review is a limited review that's governed by the Superior Court decision. However, the limit is sort of given a wide open door at the end of her remarks, as she gives 3 reasons, and the last is to do anything other that might be appropriate. So we are going to start with looking at what the staff and applicant have to say. City staff has reviewed this remand of the application for final plat. Typically, a final plat review is limited to determine if the preliminary plat conditions have been fulfilled, and if so, then the final plat would be deemed to be approved. In this case, the Superior Court judge said, you need to do a little bit more than that. I'm going to first hear from city staff and the applicant about what they believe needs to be done in response to the remand, and then in a meeting format, we'll take any other comments that people may have. I'd like to see who's here with the applicant. Can you indicate by show of hands? We've got at least 5 individuals here with the applicant, plus applicant's legal counsel, Mr. Patrick Mullaney. Good morning to you. And any other attorneys representing any other groups? Okay. So then others that are here other than applicant representatives, I think we had 5. You also would be given an opportunity to comment on the final plat review that's being conducted today. This proceeding is recorded. You can't see microphones because I'm told they're hidden in the ceiling. So be careful when you whisper to your neighbor. It may be picked up by a microphone. I don't know where they are. But it is recorded, and I think a transcript of that then could be made available if necessary. Since it is governed by the development agreement that I understand now has sunsetted, so it's no longer in place, but under that agreement, the idea of a meeting, it's not a formal hearing. I'm not going to be, as I normally do, swear people to tell truth, but I expect you to tell the truth. It's just a less formal way of looking at the final plat review that at the time the development agreement was put in place, those that negotiated and signed it felt this would be a reasonable way to go about looking at the final plat for the Talus development. I do want to say that before we get started that I looked over the Superior Court findings, and I think a little dialogue with Mr. Mullaney might be helpful on this. One thing I found a bit puzzling was that the findings were presented by legal counsel for Talus 9, but there was no indication that city council, or you're here representing Talus 7 and 8, did you sign off on the findings? Were you present when they were presented?
No, we actually objected to them, Mr. Examiner, and as you know, in fact, that decision is on appeal, so we took two paths. We've currently stayed the appeal pending this process, but the idea was we would keep both avenues open. As you're probably well aware, in a LUPA case, the Superior Court judge is supposed to sit in an appellate capacity, and they aren't supposed to issue findings of fact and conclusions of law. And we made that quite plain, but that motion was denied by that particular judge.
I see.
So that is part of what's on appeal. But that said, you know, we thought they obviously want to get the matter resolved and get on with the plat, and so we chose to go with a dual track process on this.
Okay, well, that's very helpful. I really did not have any way of knowing that, so I appreciate you giving us that additional information. The appeal is agreed to be stayed pending the outcome of this proceeding. And along with that, I think I did hear you say, you're not accepting all these findings that were entered by the Superior Court judge.
No, not at all. We think that the entire order is unlawful based on the jurisdiction that she had over the matter.
Well, I appreciate that, and we, of course, have respect and regard for our Superior Court judges, and they do a fine job under very difficult conditions. But I, too, was troubled by some of the findings made, particularly as they characterized a hearing examiner decision. It was not mine, but a colleague of mine, and it just seemed like there wasn't a fair characterization of what happened to that. So we'll leave that on the record. We'll leave it alone for now. I understand it's under appeal, and now we'll move into this phase of final plat review. And did you want to begin with that? Because you know, I've seen the city staff report. It took me a while to read it. It's pretty thick, but I got through it. What is it, 2.5 pages, if that? And, and I understand that well, it's a page and a half. Additional studies were done. That's in part in response to the remand, and that you're recommending that now it be approved. That's pretty much it, right?
Yes, and if I can start, Mr. Examiner, we talked with the applicant, and we think it is probably prudent for them to go first, but I'd like to make some initial kind of introductory comments before maybe we cede the hidden microphone to Patrick. So if you'll indulge me. So my name is Keith Niven. I'm Director of Economic Development and Development Services Departments for the city. To my right is Lucy Sloman, Land Development Manager. To my left is Doug Schlepp with RH2 Engineering, which serves as an engineering consultant for city staff. And then Jim Johnson with Golder Associates is in the audience, also here representing the city's position on this remand. As you said earlier, the way we took this problem or this tack or this work product was there was an ask to go back and look at some additional geotech concerns that were raised by an adjacent property owner. I don't know if that property owner has a representative here today.
Is there someone here representing Talus Parcel 9? They elected not to be present.
Okay.
Did you receive any comment from them?
So we did during the process, and Doug's going to explain the process we did go through when we get to kind of our phase of the presentation. But we worked with that property owner to share the geotech reports that the applicant had done, and to also share the comments that came from the city's geotech experts. So they've been kind of in the kitchen along the way, so to speak, and I have not heard from them that they have any concerns about the outcome of the additional work.
Is there anyone here that's monitoring this proceeding for Talus Parcel 9 owners? Or anyone that has an interest in Talus Parcel 9 in any way? Well, no one's admitting to that. This might be a very quick proceeding then, because I would take it if there's been no comment, no one is present, then they did receive notice of this final plat meeting, correct?
They did.
And your staff recommendation?
Yes.
Okay, so I would take it that means no objection. Is there any way other to take it?
I would take it as that as well.
Yeah, okay. Well, that might, we'll see what other comment there is, but that certainly is a different route than might go otherwise. If there were objections, we'd have a different type of proceeding. But based on, you were about to tell me what types of interactions you had with the Talus Parcel 9 representatives as well as the applicant, and apparently came to some agreement, which is why we're here today.
Right. Talus Parcel 9, as you read from the lawsuit that was filed on the previous final plat decision, had concerns over geo-technical stability. And just to point out on the map, Talus Parcel 9 is this area right here. And 7 and 8 is this area above it. So this goes elevationally up the hill to the left.
And you're referencing an aerial photograph that's in our documents
It
before
is.
us today. Let's make sure we can get that reference noted for the record.
It's identified as Figure 1, and it's about 2 pages from the back of your packet.
And this was attached to a,
Critical areas, the critical area geotech study.
thank you.
So I think our, at least as you mentioned earlier, that the judge's order had 3 items, which the last one was a little bit open-ended, but in having conversations with Talus Parcel 9 owner, the only thing that they expressed concern to us over was the geotechnic stability of these properties as it could potentially affect their property. And so I think with that lens is how we conducted this additional review. And I'm not going to get into the technical details because it's not my specialty. I'll let Doug, and if we need to have Jim do that during the city's presentation.
Well, it's important what you just said, though, because there was review of final plat
Right.
in December 2016. There were a number of preliminary plat conditions that at that time were reviewed, and all were found to be compliant. And I believe then, as you just said, the notice of this final plat review is restricted to the issue of geotechnicals or slope stability, if you will.
Yes.
Okay.
That was the position the city has taken.
Uh-huh.
So with that, I'm going to stop talking and I guess let the applicant, unless the examiner has any questions right now for city staff, I would let Mr. Mullaney.
I do have a question
Okay.
for you, and I just want to make sure in my questioning that we make it clear to everybody. I touched on it in my opening remarks. In your staff report, you refer to this as a public hearing. Your notice goes out as a public meeting. And maybe you as a professional planner that for so many years has done this work, can you give me an idea of what you see as the difference between hearing and meeting?
Sure. You know, the notice of public meeting that went out, and I do see that it says notice of public hearing in the staff report. The difference in my mind is at a hearing, there is opportunity for testimony, it's open record. All of that is incorporated into the ultimate decision that comes out of that process. Public meeting where public comment is allowed is an opportunity to hear from the community or interested parties, and you know, it's whether those comments are incorporated into the ultimate decision is at the discretion, I think, of the decision maker, which is yourself.
Okay. And so in the context of this public meeting today, it's under the development agreement for final plat review. Is there any other final plat review in Issaquah that you're aware of where there is a public meeting that precedes a final plat decision?
So there's so the IMC, the Issaquah Municipal Code for final plat, identifies a requirement for public notice, but it does not say that there is an obligation of taking public comment at that public meeting. It's merely and primarily because final plat is, you alluded to it earlier, it's much more of a technical evaluation of has the more public process, which creates the preliminary plat and all the conditions that are associated with that, have those been satisfied or not? It's a lot less discretionary than the preliminary plat process, and so that's the distinction I think that's made between the two.
Okay. And this one for Talus, is this the final plat review that you're aware of, or might there be additional? You don't know? I'm not trying to ask trick questions.
That one might be embroiled in some other
Okay.
legal issues that are
Okay.
ongoing right now.
All right, but this review is under that development agreement that has expired.
It absolutely is.
Okay, and if there are others, there's not 10 others, it's a few others that might come forward. So what I'm trying to get to is this is a special type of public meeting. And you've been party to many public meetings, and some dealing with Talus, some with Issaquah Highlands, and we always look to the development agreement in those meetings, correct?
Right.
Yeah. And here we've been instructed to look a little bit beyond that by the Superior Court judge, which is the reason that you conducted those additional studies. Okay, thank you. That, I think, sets the context well. Now, Mr. Mullaney, you know I have a high regard for you as an attorney, and I'd like to hear how you can help shape this meeting today and then make sure we go in the right direction.
Well, thank you for saying that. It's very kind. Preliminarily, I guess we'd like to just establish the record, because because of this meeting hearing confusion, there isn't a record typically like you would have at a hearing, and so I do have some additional exhibits to offer, and what I'd like to be able to do is ask the examiner to take judicial notice of the prior decision and the files, like the preliminary plat file, the various permit files that are listed at paragraph 5 of the last decision that were where the preliminary plat was, the infrastructure for the final plat was built out, and there are about 5 or 6 listed in paragraph 5.
Well, thank you for beginning with that, because I was negligent in not noting at the outset that there will be a record of this meeting which identifies the exhibits and identifies who spoke and a summary of what they said, and then a transcript could be made of the recording. So that is the record of this proceeding. I know that the judge did a little bit of chastisement about the record, so thank you for our caution. We want to be careful. I will admit into the record the staff report prepared, I believe, by Mr. Niven, and he had 6 attachments to it. Public notice affidavits, or 1 and 2, the Talus Final Plat decision of December 2016, which you just referenced. That is also admitted into this record. And along with that, those exhibits that are noted in that December 2016 decision, and there's 15 of them, I'm not going to read them all. You made reference to those that are indicated in finding 5. Is that
Correct.
Yes, and that does reference a number of items dealing with parcels 7 and 8. So all of that's what's in that decision, including its exhibits and its findings and conclusions, are part of this record. So let's make that clear right now.
All right, that's very helpful.
Yeah.
Thank you.
And then you mentioned you might have additional documents
I
to
do,
submit?
So I don't know if the actual geo-technical study is part of our record yet.
The ones that were done
The one
following
that-
the remand?
The remand study.
Well, I think that's incredibly important. After I read the court decision, I thought, yes, let's make sure we have those today.
So this is a copy for you of the final report.
Okay.
In all of its technical glory.
So we will identify this then as Exhibit 7, as we have staff report with attachments 1 through 6, and then this will be 7.
So, Mr. Examiner, at some point, can we leaf through that and make sure it's the correct version of the study?
Yes, that would be.
Sure, would you like me to hand it to you now?
Yeah, we can do that while Mr. Mullane continues.
This is I got a bunch of documents on drives. That's the appeal
Oh.
record, the appeal record.
Didn't know what was gonna be in
He
here.
thought it was anthrax.
Yes. You gonna come down here and drive this, Patrick?
Well, I wasn't gonna put it all up. I was just gonna offer it. There's 1,700 documents
Oh.
on it total, so.
So is there one for the city and one for the Examiner?
Yes, exactly.
Okay, I get it.
And,
Do you care who gets which one?
that's for you. and
I get the little one, he gets the fancy one?
No, there's actually so many documents, there's 2 drives worth.
Oh, so this is our copy.
Yeah.
I'm tracking at this point, sorry.
And those are, what I'm gonna offer are the lists of the
Okay, so
files
you've
that are-
annotated what's on the drives?
Right.
Okay, awesome. So is this gonna be Exhibit B, Mr. Examiner? What was that one?
Well, I saw that you had identified attachments 1 through 6.
Yes.
So then I thought this geotech report would be 7. Now
And
this
8.
is an additional exhibit?
Yes, he has one of these for you as well. It's
So-
thumb drives and table of
So I'll
contents.
explain it to you, Mr. Examiner. So what we have are, there's 2 thumb drives. One is labeled Foster Pepper, and for your copy, there's a black thumb drive too. The Foster Pepper drive includes all of the exhibits that were used in the prior LUPA proceeding and went to the Court of Appeals. So that was the geotechnical record that was established back then.
Mm-hmm.
This black drive, and I listed the files because there's actually 1,600 documents and pictures and things on it, so it was kind of voluminous. This is all of the backup documentation from Pangeo, the firm that prepared the report on remand. That's all the documents that they collected, reviewed, their field notes,
Okay.
investigations.
So maybe it's 2 separate exhibits.
That's correct.
One is the LUPA record. Is that, yeah. You got it down to how many documents?
I think there's 61 on that one.
Okay. So that's exhibit 8.
8, okay.
LUPA includes a mandate that the parties shall cooperate in identifying those items that are relevant for review. And that's what that is.
That's correct. And that's the record that was transmitted to the Court of Appeals,
Division 1.
Division 1.
Okay, exhibit 8, and then exhibit 9 is the Pan-Geo support documents.
That's exactly what they are.
And I'm sorry, did they do the geotech report?
That's correct.
Support documents for exhibit 7.
They were the authors of it. They worked in conjunction with Ted Shepard at Terra Associates, and he's here as well. He was the original geotech that did the critical area studies for the preliminary plat.
Okay,
So they collaborated on the document that Pangeo authored.
Mhm.
Mr. Tan is here from there to testify.
so it was your client or the Talus 7-8 that retained
That's correct.
Pan-Geo to do geotech? Okay. And that was in response to the remand that said additional studies. All right. Any other documents that you wanted to submit for the record?
That is, let's see, I'll just make sure. I believe that's all that I have, Mr. Examiner, for additional documents.
And then these documents are in fulfillment of the remand, do you believe?
That's correct. As you can see from the, so Keith, did that copy pass muster for?
Yes.
Okay.
So I didn't see in here the lot 5 slope stability design or the comments. This is just the Pangeo report.
Oh, okay, so
Is this just the Pangeo report?
I believe so, but maybe Mr. Tan should take a look at it, because
We have this document.
okay, well, while they're going with that, to answer your question, Mr. Examiner,
Sometimes there's some
the
back-
report on remand
this one.
is the synthesis of all of the prior geotechnical information that was available for parcels 7, 8, and 9, and the additional geotechnical information that was collected through on-site observation, additional borings on parcels 7 and 8, and then also separately but simultaneously, parcel 9 was in with the city to construct remediation on parcel 9 to remediate the effects of the landslide on that property. And to do that, they obtained permits for some geotechnical walls, and their geotechnical consultant, Hart Krauser, generated geotechnical reports, a CAR for that property, and that information was also included in the report on remand, and it's also in the files that I handed up to you as the background information from Pangeo.
Okay. And since we're governed by the remand, in that remand, finding 48 requires these 3 additional items. Additional site exploration and analysis of the soil conditions and overall slope stability on parcels 7 and 8. Is that what Exhibit 7 is?
That's correct.
Secondly, an updated critical area report or reports incorporating the findings of the additional exploration and analysis. Is there additional updated critical area reports?
That's what Exhibit 7 is.
Exhibit 7 includes both
That's correct.
those items. Because a critical area report is prepared to be consistent with certain required elements that the city code includes, right?
That's
So
correct. And this report was peer-reviewed by Mr. Johnson and Shannon and Wilson.
And that's also mentioned that there be peer review of those reports. Is that also in Exhibit 7?
They will have Mr. Johnson, and I believe the city's engineer can testify that peer review occurred. And on the black thumb drive that I gave you, there are several rounds of peer review comments that the city generated during the process when they were reviewing the findings of the.
That's Exhibit 9, which
That's
was
correct.
entered as the Pangeo support documents for geotech report and peer review comments.
That's correct. That that drive also, as part of the supporting documents, are the peer review comments from the city.
Okay, I'm going to modify our description of Exhibit 9 to include support documents for the geotech report and peer review comments. And then the third instruction from the Superior Court judge is to do any other proceedings and relief as are appropriate based on this court's findings of fact and conclusions of law. And you looked at that very carefully. Did you see anything else that might be appropriate based on the court's findings and conclusions?
No, and you can look at the transcript for the last meeting, and you can also look at the Lupa transcript if you like. Those would be on Exhibit 8, I believe. You'll see that Parcel 9, the owners of Parcel 9, or a Talus 90, did not appeal any of the 32 conditions. They did not, were approved, that the hearing examiner found were met by the final plat. They didn't appeal anything other than the geotechnical CARs, and their argument could be boiled down to the CARs for the preliminary plat were produced in 2014. We had a landslide in 2015, albeit not on parcel 7 and 8. It was only on parcel 9. Therefore, we would like additional geotechnical review. So that's the issue that was presented to the Superior Court, and that resulted in this order. So I don't know what other appropriate relief would be other than to conduct the investigations, have this proceeding that we're in now.
Okay, so I appreciate that. Your opinion on behalf of the applicant is that there's been full compliance then with the remand by the Superior Court judge. And I'll note that the remand with those instructions, that does complete it. I would agree. We'll see if anybody disagrees, but there isn't any instruction to then add additional conditions. It's similar to what an EIS might do. You can revise your EIS, but it doesn't say, and then you must add some additional conditions.
And in fact, I believe the staff report, based on the revised study, does add 2 conditions for Lot 5.
Can you speak to that, Mr. Niven? After these reports were done, Exhibit 7, and you looked at that, the geotechnical report, did you see a need for any additional conditioning?
We did. So there's a couple additional geotech conditions, as Mr. Mulaney referenced, and we also are going to, later on in these proceedings, ask the hearing examiner to add an additional condition relating to a posted surety on the water reservoir, and I can explain that later when we get out of the geotech world.
So I'm now looking at the last line of your staff report, and you do recommend that the conditions from the critical area decision dated August 6, 2018 be
So that's
incorporated.
that's an attachment to the staff report. It would be attachment 6.
Can you describe what those additional conditions would be?
I'll let Mr. Schlepp do that.
My name is Doug Schlepp. I'm a development services engineer and project manager for Talus Parcels 7 and 8. And I just want to go back a step. We reviewed Exhibit 7 and found that consistent with the referenced documents in the staff report dated August 6th, 2018. There are 3 bulleted items within the decision section, and that would be the first bullet item that's referenced. And it's the June 27th, 2018 report that is at the end of that first bullet item.
Yes, I see that on page 1 of the staff report dated August 6, 2018.
And then the second bullet item, which is the summary of the critical area report peer review comments. We do not have a hard copy of that, but we've included that by this reference here. It is apparently on the thumb drive that you've received, which is Exhibit 9. And if you would like, at the end of this meeting, I can provide you with a hard copy of that for your use and records.
Well, so these 3 bulleted items, from your review of those, and I didn't quite understand that, they are part of this record, or they're not part of this record of this meeting?
They are by reference, so we had not included them as you can see the volume, we did not include them as a copy in the notice of decision for the staff report, but we included them by reference, which is common.
Common in your world? It's not common in my world.
And that's, I need to know what you need for.
Well, I'll tell you what I need to think about now is loop appeal.
Yes.
And loop appeal is based on the record created in the hearing room or apparently the meeting room. And that means documents that we actually have in front of us.
Yes.
The reason for that is, just as you went through Exhibit 7, oh, is this really the right one? Everyone needs a chance to look at that and see if it's the appropriate document and to know what it says. By reference, it may not even exist. That's been, I'm not saying you would ever do that, but I have encountered that. Oh, you made a reference to it, it's been appealed, we can't find that document. And my office will get a call, do you have that document? Because it was referenced at the hearing. So let's get it in this record.
Sure, we can provide that.
Given the history of this review, we need to have the document in the record. So you can provide that how?
We'll provide that to you today.
Before we close the hearings,
Yeah.
or the meeting.
Okay, and it's available for public review,
Yeah.
and Mr. Mulaney has a copy for his client review?
That was part of this process of review, and it's noted in the directory that's on the thumb drive.
Okay,
I haven't reviewed his thumb drive, but we will provide you with a hard copy.
so it may be digitally on one of those?
That is correct.
Are you confident it is digitally on one of
I
those?
didn't review the thumb drive information, but I will provide you with a hard copy.
Okay, and it's not only about me.
No, but for the process, it's not
The
a
record.
it's a simple matter. It will just take me a minute to get.
Okay.
Yeah.
And what I will do then is keep the record open, because I want others to be able to see that in case there's
Sure.
an objection to it. I know this is less formal than a hearing, but I'm being especially cautious. So let's say the record's open through close of business end of the week, Friday, and if someone sees that and says, oh, we think this is wrong, or it's not what he said it was, they can comment. They can provide a written comment to the city, who will get it to me.
And then the third bullet item is included in the staff report as an exhibit at the end. And that's the GeoPeer plans.
All right, I'm trying to catch up a little bit, because Mr. Mulaney, on behalf of Talus Parcels 7 and 8 ownership, says, okay, this report 7 is what we did in response to the remand. Now, these three you just mentioned, one is that, correct? The updated critical areas report, Talus Parcels 7 and 8, prepared by Pangeo. That's the same document.
Exhibits, yeah.
Dated January 2018, revised May 24th, 2018, and June 27th. That's the Exhibit 7.
Yes.
Is that right? Okay.
That is the June 27th report, which is the culmination of the critical, or the peer review. So
Okay.
you're getting the final document that was ultimately prepared, not
Got it.
the interim documents that were submitted.
Which is fine. I just need to see the final. And then that second bullet, the critical area report peer review, that was said to be part of Exhibit 9, or is this something different?
It would be electronically, and
We're
we're
gonna
gonna
provide
provide
a
you
hard
with
copy. We'll call that Exhibit 10.
Yeah. Okay. And then the third is the Talus Parcel 8 Lot 5 Slope Stability Enhancement. Dated
That
July.
is part of the staff report dated.
So that's part of Attachment 6 already.
Yeah.
Okay, thank you. And please continue. Anything further?
And to get back to your initial question about the two conditions, as part of the additional study, two conditions were placed on this plat. The first one is relative to the slope stability of Lot 5, which is part of Exhibit 6. And generally, that is in this area right here of what is called Parcel 8. The X is roughly.
Mm-hmm.
And then there is a condition to make regular maintenance inspections associated with the slope in this area right here above these lots. And that would be condition 2.
To be added as conditions of final plat approval.
Correct.
Thank you.
We want to talk about the non-geotech conditions now.
I don't know if it's appropriate to do that now, or do we stay in geotech land for a while? So, Mr. Examiner, I think the choice is we can either add, the city's proposing a third condition, which you don't have yet. We can either talk about that right now, or we can stay on the geotech thread and get to that later. Your choice.
Okay, I'd like to hear next from any public comment that there might be in this meeting on final plat review, and then we'll get back to staff and applicant. Is there anyone here that wanted to speak to this final plat review? Any member of the public that wanted to say anything? Okay, going once. I'll give another opportunity later. Guess not. So no public comment to date, no Talus 9 comment. So let's go back to Mr. Mullaney and see what do we need to do anything additional today?
Well, I thought that I would have the geotechnical engineers come up and briefly explain what they did, and so you have a feel for that, and then what their findings were.
So let's check in on that for a moment. And I'm being less formal because it's a meeting, we're not a hearing. But coming here today, I did not know if there'd be any objections to the additional reports or any testimony or comment from the Talus 9, because that's why we're here, really. The Talus 9 objections that went to Superior Court. And I thought, well, if they're having further objections, they'll need to be present and tell me what they are, and then I'll need to take that into account in how to decide the final plat. Now, given that no one's here from Talus 9, and there's been no written comment, and apparently no verbal comment even to Mr. Niven, has there, Mr. Niven, on these recommended conditions or the reports?
Not on the geotech, no.
Okay, so that's closed off in my mind. So I'll leave it up to you. If you want to put some material on the record other than what's in the reports, I'll give you leeway to do that. I'm going to rely on the reports. But we could have brief comment if you'd like.
Yeah, why don't, I can probably just, I have 2 questions for the city's peer review engineer and just a couple for our.
Okay, and that way they'll be in the decision that they'll then reference their reports. Okay.
And and just to give you a little bit more on the parcel 9's position, I believe, Keith, were you copied on the email that was sent to Jim Haney, or did you talk to him about that?
I did not.
Oh, okay.
You mentioned Mr. Haney. Was he the city attorney that was the attorney through this LUPA
That's correct.
process?
Yes. And I can represent that I've seen an email communication from counsel for parcel 9 to Mr. Haney that said that in light of the additional geotechnical review on parcel 7 and 8, and in light of the approval of the remediation for parcel 9, that they did not intend to participate in these proceedings or object to the final plat on remand.
And that's assuming the final plat on remand references the studies and adds these additional conditions. We know of 2, and then I guess there's a third one you're recommending. Why don't we get that out on the table and then bring your experts forward after, because I'm really curious, what's this third item that we're only hearing about today?
A little bit of minutia, but still important. So, as the examiner is aware, IMC 1813-280 allows for deferred improvements with final plat. So basically, we're talking about infrastructure that is not completed but has been financially guaranteed by the applicant, which allows for the final plat to be approved. And there is, when this final plat went through previously, there was a number of infrastructure improvements that were bonded for by the applicant. And since that time, they have moved forward and constructed most of those, which is good news. But there's still the city has not accepted the water reservoir at the top of the hill, which will serve this plat and the homes that get built there. And as that facility got constructed, there was an outstanding maintenance concern that the city raised with the applicant. And so I am asking the hearing examiner to add a condition related to the provision of maintenance compensation for the city. So there's a joint agreement that the applicant and the city have executed, and what I would like for the hearing examiner to do is add a condition that references that agreement.
And you've given me language that would do that.
Yes.
And
I've
Mr.
given
Laney,
you
you've seen this?
language that suggested how I would do that, and if you would like to phrase that in different words, that would be fine.
Okay. You've seen this?
Yes, let me just take a look to
So
make sure. I've
the
seen
applicant,
that.
legal counsel is reviewing it. Yeah, we're gonna mark it as Exhibit 11.
Okay with it right there. You signed it, so I assume you're okay with it.
I signed it. I have not seen the condition or the language
Oh.
associated with it, but I have seen the agreement, and yes, I have signed it.
The condition reads, approval of the final plat is reliant upon, attorneys will have fun with that one, is reliant upon the execution of the 9/12/9/12 reservoir maintenance agreement dated August 15, 2018. Now, it has been signed, so
Yes.
the condition is fulfilled?
Well, no, because if you read the last bullet point on that condition, Mr. Examiner, you'll see that the applicant has volunteered to offer the city $150,000 for concerns that the city has raised over longevity of that structure for added maintenance costs that will be a burden on the city. So that was a negotiated outcome between the applicant and the city, and this agreement memorializes what was agreed upon, and so that condition, we wanted that to be publicly facing as much as it can be, so putting a condition on the plat referencing the agreement seemed like that was a good way to do that.
Okay.
So that any buyer of that property would understand that there's that obligation out there.
Great. I will be done. It will be done.
Thank you.
Looks like Mr. Schlepp has returned with
With
hard copies.
exhibit, is that, what do we call that one? Was that 10?
I think so.
Yes, thank you.
Anybody else?
You have
Okay,
one- you
we'll
have one
note
paper
here
Glasses.
for the record of the meeting that Exhibit 10 has now been distributed. We'll still keep this record open. If there are comments from anyone present, submit them to Mr. Niven's office, and he will transfer them to me. And that's records open until Friday at 4:30. Did you need a minute to look at that?
No, I'm fine, and we're fine with these comments, Mr. Examiner.
Okay, so now we'll return back to applicant's attorney for some brief presentations of the peer review of the reports.
So I guess I'd like to call up Mr. Tan to explain to you just, he is from Pangeo and was the principal geotechnical engineer on the report, so he can kind of
Let's
give
find a
you.
comfortable place. Where's Mr. Tan? Okay, I think you can stay right there if you
Okay,
want.
that sounds good.
You know?
Thank you.
There's no no swearing in. We don't really have a witness stand, or
Yeah.
we're winging it here as we go, but I can see you if you're comfortable there.
Yes.
Okay, and your legal counsel can ask the questions, so.
So, Mr. Tan, could you just state your full name and spell your last name for the record, I guess?
My name is Siew. First name is Siew, S-I-E-W, and last name is Tan, T-A-N. And I am a principal at PenGeo, a local geotechnical consulting firm.
Could you describe what you were asked to do regarding the investigation of the geotechnical conditions on Talus Parcels 7 and 8?
Right. We were asked to review the previous critical area report and identify potential deficiencies and do an independent analysis of the existing conditions and to update the report. Because
Who did that report?
the previous report was done by Terra and Associates.
Okay.
And in your updating of the critical area report, did you review the prior geotechnical documents associated with Talus Parcels 7, 8, and 9?
Yes, we did. We reviewed the previous critical area reports.
And did you also do any additional site exploration and analysis?
Yes, we did. We drill additional test borings. We review construction records for what has been built at 7 and 8. We review previous studies regarding the slope stabilities for the area. So in section 2.0 of our report is basically a laundry list of all the documents that we review.
And so did your site exploration and analysis include examination of soil conditions and overall slope stability on parcels 7 and 8?
Yes, we did. We did an independent analysis of the slope stability.
And was that independent analysis included in your updated critical area report that we have as Exhibit 7?
Yes.
Could you describe the peer review process that you went through with the city?
Sure. I mean, before we finalize the report, we produced draft reports, and those draft reports was provided to the team, and I believe that the city forwarded those to Golder and Associates and Shannon Wilson to comment on it. And we also have at least one subsequent meetings to discuss some of the comments, and those comments were incorporated into Exhibit 7.
And could you briefly explain the conclusions of the CAR?
Right, the CR basically, in Exhibit 7, we identify that Parcel 7 meets the requirement. Parcel 8, we found that Lot 5 require additional stabilization efforts, and that subsequently lead to the design by GeoPL Northwest to reinforce the soil condition in order to achieve the stability that we were looking for and the team was looking for.
Okay, thank you.
And then, just to follow up then, do you have a professional opinion on whether the prior geotechnical information for Talus Parcels 7, 8, and 9 and the additional testing done on Talus Parcels 7 and 8 adequately characterize the geotechnical conditions on Parcel 7 and 8, including the risk of possible earth movement?
Yeah, I think the updated critical area report addressed those. The previous report was done before the construction happened. So it's not directly applicable to what we are evaluating here. So I think I will just focus on the updated critical area report.
And then do you have a professional opinion on whether the proposed final plat, as conditioned with the 2 additional conditions we discussed today, is adequately protective of public health and safety from a geotechnical standpoint?
Yes, I do.
What is that opinion?
Yes, the final plat as approved with the conditions will adequately protect the publics.
That was
I don't
all.
think that's what you were asked.
Uh,
Did you ask about public health?
Health
I
and-
want some key words here.
Yes, okay, very well. It's, the question, Mr. Tan, was, do you have an opinion on whether the proposed final plat, as conditioned, is adequately protective of public health and safety from a geotechnical standpoint?
Yes, it does. So,
Okay, and I don't think I got this in the introduction. You're a professional engineer? with
yes, I'm a
NGO?
professional engineer. I received my bachelor's and master's degree from the University of Washington. I have 30 years of experience practicing geotechnical engineering in the Puget Sound area.
Thank you.
That was all the questions I had for
Yeah.
Mr. Tan. And then
Thank you.
I just had 2 for Mr. Johnson, who was one of the peer review engineers.
And where is Mr. Johnson? Are you comfortable sitting there?
Yes.
Great.
So I guess I got 3 questions. Mr. Johnson, could you please state your name and spell your last name for the record?
Sure. Jim Johnson, Johnsson.
And could you briefly describe your educational background and professional experience?
So I'm an engineering geologist. I'm a principal at Golder Associates. I've been there for 31 years. I'm practicing in local geotechnical practice.
Could you briefly describe what your role it was on the CAR that was produced on remand here?
Sure. So the city of Issaquah hired Golder Associates and Shannon and Wilson as a team to provide the peer review of the work done by PanGeo. I was the manager for Golder Associates, and Martin was the manager. Page was the manager for Shannon and Wilson, and together we reviewed the PanGeo progress reports. We wrote comments and provided those comments to the city and then back to PanGeo. We reviewed their responses. We met with them when appropriate to go over some of the issues in the comments, and then we issued a final set of comments addressing whether or not all the comments have been adequately addressed.
And based on your involvement in the project, do you have a professional opinion on whether the CAR adequately characterizes the geotechnical conditions on parcels 7 and 8, including the risk of possible earth movement?
Based on our review, it seems that it does.
And finally, do you have a professional opinion on whether the proposed final plat as conditioned is adequately protective of public health and safety from a geotechnical standpoint?
Yes.
And what is your opinion?
Meaning that it does.
Thank you, sir, for being here. Any further witnesses from applicant?
No, I think that that's sufficient.
Okay.
Mr. Examiner.
Anything further from the city?
I believe Mr. Schlepp has at least one additional thing he'd like to provide.
So as part of the staff report and the condition regarding the slope stability of Lot 5, we have a subdivision bond that we would like to enter as an exhibit. I believe that would be 11.
12. We'll mark it as Exhibit 12.
12.
Exhibit 11 is the additional condition.
Oh.
So subdivision bond.
And which condition, Doug, was that related to, number 1 or number 2?
That's related to number 1.
That's the geofence.
Yes.
Yeah, one thing mentioned, Mr. Niven, in your staff report is that there's been Public Record Act requests. Were those fulfilled? Were those materials supplied prior to this meeting?
As far as I'm aware, so the city typically responds to those in installments, and we have been producing documents for the requesting party, and as far as I'm aware, we are not in violation of their request at this point.
And in any event, are you aware who the requesting parties are?
I am.
Are they present here today?
I'm not sure. We could ask if the examiner would like to know that. We could be as generic as saying if.
Well, you were specific, I think, in your report of who requested.
Okay. So I do know who requested. So
I just want to know if they're here.
So is anybody represent Toll Brothers in the audience? Yes, there is someone representing Toll Brothers in the audience.
Any objection to this proceeding going forward? Who is that individual?
Ryan Sternoff, counsel for Toll Brothers, and I'll just say no comment on the proceedings going forward.
Okay, they were present and elected not to comment, so to me that waives any objections. Okay. Well, I think we've come. I'll ask one more time. Any public that want to comment on this final plat meeting? No one's indicating that. So I think we've come to a time to close this meeting. Any final comments, Mr. Mullane? I know you mentioned at the outset that there's an appeal, but it's on hold pending the outcome of this proceeding.
That's correct.
And is the anticipated outcome approval of final plat with the conditions that we've discussed today?
Yes, if that's where we end up, then the appeal would be dismissed.
Okay. Well, we're happy to have a hand in that.
Thank you.
Because it's rare that any resolution is reached through a judicial proceeding. And that's why we've been somewhat flexible with this meeting, to make sure we get all the issues out in this meeting, and that we're confident that we've addressed the directives on remands from the Superior Court judge. And it seems like we have done that. There are parties here that may have objected to it, but they have not. Other parties chose not to attend. So I think we've done what needs to be done to allow this to go forward with final plat approval with the additional conditions as mentioned, and to get that decision out within the next 2 weeks. Okay. So the meeting is adjourned. Thank you all for coming.